morning and welcome to our Lawdit Solicitors podcast. I'm joined by Izaz Ali, who is a solicitor. My name's Owen White and I'm a trainee solicitor here at Lawdit. Today we're going to be following on from our previous podcast on due diligence, and we'll now be going on to the disclosure letter that relates to the due diligence. So if you haven't heard that podcast, please feel free to listen to that as well before you listen to this one, because we're going to touch on some similar topics in relation to that.
Absolutely, yeah. So in relation to the disclosure letter, very quick recap. So due diligence exercise goes through a whole host of different aspects of a business, from what their IP is, what licenses, software, what they're using, employees, the buildings that they occupy, whether it's leasehold, freehold, relationship with landlord and neighbours and all that sort of stuff. And then you'll look at products and services that the business that you're acquiring has, or that you're selling has to offer, and any issues and warranties and indemnities and guarantees in relation to that. So a whole host of things. But what that then culminates in is that if you come across any issues that you identify whilst you're providing the information relating to the business that you are looking at selling or purchasing, anything identified needs to be dealt with in the actual business sale agreement, whether it's an asset sale or share sale or purchase agreement. Now, when you go through that exercise and you negotiate the terms of that, you have something which sits on the side of that agreement, and it's called a disclosure letter. So in the actual main body of the agreement, you give certain assurances to the prospective buyer, for example, and they will be, for example, let's just take employees as an example. So you've said that there's no issues with any of the employees. You've got contracts of employment in place for all of the employees. You've got set grievance procedures, disciplinary procedures. You've got no issues with any rights of any minority in your workforce and all that sort of stuff. And then, so you give a firm assurance to the prospective buyer that is the case. But take, for example, you have an employee that's raised a grievance in relation to a matter relating to another employee. That sort of thing you would then put in the form of a disclosure letter. So in the disclosure letter it says we're signing up to this agreement in accordance with the terms of that agreement between the buyer and the seller. This is a warranty which says that there are no issues with any of the employees. They've not raised anything with the employer, and that, for example, in the main agreement is clause 2.1 of a schedule in relation to employees. You have a disclosure letter. In that disclosure letter, you put down warranty number 2.1 is qualified, potentially. You say is qualified as follows, and then you put down this employee has raised a grievance with us in relation to what was said and done with that. That's a live issue. It's not yet been resolved. We're currently investigating that position, and the outcome of it has not yet been determined. So just that little disclosure there shows the prospective purchaser or the buyer that in relation to this business, all of these points in relation to the employees, I've got an assurance from the seller that this is the case. However, he's qualified this point. And then the point that you qualify, the buyer can then come back to you and say, at that point ahead of signing, can you provide further information? Can you provide a copy of the material that you've got that you're using that forms part of your investigation, so that the buyer and his legal team and accounting team can then take a view of that. And them taking a view of it means that they can then calculate their risk and any issues pertaining to it. So that's just like one example, but effectively the disclosure letter is like waving a flag, waving a white flag and saying, hey, in relation to that, watch out for this, yeah? This is what we want to disclose to you, this is what we want to tell you. And I always say to clients that if you have anything that's of concern, you must have a relationship with your lawyer and accountant where you can just openly discuss that with them and say, right, how can we How can you help me to package this? How can we make this as a disclosure? What is the cost and expense of this if this was to be a problem for us? And how can we deal with it or resolve it or, in some way mitigate it, i.e. lessen the impact of it? So that's really the sort of point in relation to a disclosure letter and the example of a employee scenario.
So am I right in saying that once the buyer has acquired the company, the risk is transferred to them at that point of any specific disclosure?
Yes, provided that, so just sort of drilling down into that deeper, with employees, there's some legislation which we say in short as 2P, as in TUPE, and that stands for the Transfer of Undertaking Protection of Employment. And in relation to that aspect of it, employees will go from one company to the new company or remain in that company with a new owner effectively at the helm of it. So that's that aspect of it. Now, very interesting point you made was that if you've made a disclosure, then effectively the buyer's aware of it and the buyer will have to take any risk with it. But the buyer will then at that point look at the wording of the agreement and say, well, actually, it was down to you to make a full and frank disclosure and not hold anything back fraudulently or wrongfully or make any misrepresentation of the facts. So all of those sort of things come into play, and your pushback to the buyer is, well, ahead of signing, you had the ability to ask a lot more information and to sort of drill down and get a better understanding of the problem, and you were guided by professional advisors. So you're not an average buyer, you're effectively a buyer that's got the benefit of this additional help and support. So these sort of things are really, really important, and this is why, back to the same point, that you've got to package it and you've got to present it and give them enough information for them to make an informed decision, and so much so that you've got to do it in a way that you don't want this to come back and bite you on the bum.
So it's also required that you need further due diligence on the disclosures provided in the disclosure letter.
Absolutely, yeah, absolutely. And we do come across situations where a buyer will be happy to go ahead with a prospective purchase, notwithstanding certain disclosures that are made, but in relation to further protection for themselves, they may come back and say, well, actually, the issue here could be a fine of some sort, or we may have to pay out some damages, or we may need to settle this case, in which case, with a particular employee, we need to earmark a fund of £10,000, for example. So we want to adjust the purchase price accordingly, or we want to effectively keep back £10,000, and within 18 months, if and as and when this case is resolved, we'll deduct from there the cost and expense of that case. So your maximum liability as a seller is going to be 10k if things go south, but if they don't, then it'll be the balance of that with us resolving it, and obviously the seller will want to have some input in relation to the continuing investigation, etc. So these sort of things happen, but there's lots of ways to get round having that problem and sort of seeking a solution that's amenable to both buyer and seller in those circumstances.
Yeah. So I believe that covers the disclosure letter. So feel free to get in touch if you'd like to contact us about selling your assets or shares in the business. And thank you for listening.
Thank you.